Thank you, everyone, for joining us here for this this segment. We're going to talk about solving for PTAB risk. It's a litigation funding perspective. We'll talk about everything that's going on at the PTAB, and I'll introduce the panel from left to right. We have Anup Misra, and Anup is director of Curium Capital LLC. Thank you for being here, Anup. And you're a funder, right?
I am a funder, yes.
Okay. We have another litigation funder, Sarah Sao, and she's portfolio manager of global intellectual property and senior investment manager at Omni Bridgeway. Sarah, thanks for joining us. Then we have a patent owner here who's using funding and also litigating. My friend Brad Close, I've known Brad for, I won't say how long, we went to law school together a long time ago. And Brad is Executive Vice President of Licensing and Transactions at Trans-Pacific IP Group. And last but not least is Jim Carmichael. Jim is the founder and managing partner of Carmichael IP. He's a co-chair of the program, and he will moderate the panel. So Jim, how about I let you take it away?
All right, sounds good. Following in Gene's tradition, I'd like to ask each of you for opening thoughts on the topic of how to solve for PTAB risk from the litigation funding perspective. Anup, let's start with you. You're on the far left.
Yeah, sure. So, I don't know if you can ever really solve for PTAB risk, but we can mitigate it. And I think one of the things that's going to come out in this conversation, I think, is that there's really two perspectives about this, right? There's mitigating it from the patent owner's perspective, and that's really how do I win my IPR. But there's also mitigating it from the funder's perspective, which, will be closely aligned with that. We certainly want to win the IPRs, but sometimes, if we're going to, we know we're going to lose some IPRs. Sometimes the angle is, how do I not burn through too much capital getting to that loss, if that makes sense. So I think that's kind of two closely aligned but slightly different perspectives that I'm sure we'll talk about significantly.
Good, thank you. Sarah?
Yeah, I agree. And from our perspective as sort of smart funders in IP, I certainly think we have to assume the risk of IPR, particularly with Ventive being essentially a dead letter. But there are other perspectives. So there are some funders out there who are interested in IP. They might want to avoid the risk entirely, and that means they're looking at cases that have overcome IPRs already, either in the current case or in a prior case. That's not always realistic, and we find that the best cases are those where we can get involved early and where the risk is yet to come. And I think what we try to do as well is to solve for that risk. And we'll talk a lot about that today, but one thing we can do is case and patent selection, so making sure that we are working with our funded counterparties to develop a diversified strategy where all the patents are not rising and falling together, always assuming that they're going to be potentially instituted and having to go through the PTAB process. We can solve for this by counsel selection, working with very good IPR counsel with amazing track records. Sometimes that's at specialty counsel, sometimes that's among the litigation team itself, and we'll talk a little about that today as well. And the other way we can do this is to actually address it through structuring. So there are many things we can do in our funded arrangements, including milestone success fees for lawyers when they overcome certain milestones within the IPR, to incentivize everybody to work hard to overcome what is one of the most significant risks in any valuable patent case. And we can talk more about that as well.
Great introduction. Thank you, Sarah. Brad?
And I think my biggest takeaway, and I can keep coming back to, is it's a little bit more like a numbers game. We need more patents in early if we're actually going to go and litigate. It really can't be one patent, one claim. You have to get some diversity in what you're asserting right from the get-go.
Thank you. Now, panel, I'd like to ask you this. For those in the audience that might be interested in obtaining litigation funding in general, and for IPRs in particular, how should one, a claimant, I think you call them, how should a claimant go about trying to line up litigation funding? Brad, would you like to start as someone who has done this?
Sure. So coming at it from more of a business point of view in NPE, we look at a lot of patents, and a lot of people want to sell us patents in big groups, but ultimately we take the much bigger list down to the smaller list, still have a group of them. And then we have counsel lined up, we have claim charts, we have prior art searches. So you have to get the whole package, you have to prove the worth and the likelihood of success, no one can guarantee it, but the likelihood of success of your portfolio. And then you show that as an entire package to a litigation financier. So that will include the claim charts, it will include the prior art searches, the attorney representation is already there. And hopefully you also have a little bit of your own track record that you can point towards as well.
And that package, I assume, would include evidence of use.
Yes, that's sort of what the claim charts are. So very, very detailed, sometimes reverse engineered, like ready, litigation ready claim charts. The term claim charts can be used a little lightly sometimes. Some people call them evidence of use, and they could be a little bit of hand-waving type thing. So what we need is the actual line-by-line claim charts that really get into the details and really show the infringement.
Sarah, what do you like to see in a claimant's application for litigation funding, if those are the right terms?
Yes, so certainly claim charts, and we're talking about validity issues, but those things, as I'm sure everyone in the room knows, go hand in hand with infringement. So the starting point is the infringement. Various claims of varying breadth and the strength of the reads on each of those claims, and only with that information can we then assess validity. So for every claim that is broad enough to be infringed and clearly infringed, it will be exposed to higher validity risk. And so what we like to hear in the application, either in writing or we're very flexible, we can certainly do this in a conversation with everybody, is to answer the question I like to call that's great, but what if? So for every risk, including liability, so infringement and validity going hand in hand, or damages and so on and so forth, we will always ask the question of, okay, that's great, you have this broad claim, it's fundamental, and it's clearly infringed, you have great evidence of use, but what if that claim goes down in IPR? What will we do then? And the best is when people are ready with answers and they've already identified a narrower claim that perhaps is a little bit harder on infringement, but will survive some of the anticipated arguments that we can foresee in the PTAB. And then just keep going level by level until we figure out where does this end, and understanding how much diversity do we really have, how many steps can we, where we can fail at the PTAB and still be left with a viable claim, hopefully with still some diversity left, hopefully that still covers the same scope of damages and still supports the same royalty rates that we all relied on for the investment. So having an application that ticks all those boxes and maybe even going beyond the prior art that was cited in the patents to independent searches, that would be like A+, but we will certainly consider anything short of that, because I think part of our value add is that we can ask those questions, and if people have not necessarily thought all of that through, we can help guide the process with all of our experience to get the package in a position where we can all move forward happily with the funding.
So Sarah, if the claimant's answer to what if is, I got other patents too, how does that strike you?
Okay, where are the claim charts for those patents? And how different are they? So, the number of patents is one marker, but it matters, the number, it's more than just a number. So if you have 3 patents, but they all are part of the same family, they're all vulnerable to the same prior art references and combinations, they all sort of rise and fall together, that's less good than if you have just 2 patents, but from very different families, both of which are reading onto the products, both of which would support the damages at issue. So yes, I think that's a great answer, but then we'd want to know more.
How about you, Anoop? What do you like to see in a claimant's request for funding?
Yeah, a lot of what Sarah said is going to be applicable to myself and Curium as well. But I do expect claimants to come with me having done at least the validity search, independent validity search. I think you're doing yourself, and if you're a lawyer, your client, a real disservice by going to a funder without having that knowledge. Because while you can't ever figure out every combination that's going to be thrown at you, or everything that's out there, that's impossible. You're not going to be able to do that sort of full PTAB analysis that a petitioner is going to end up doing after they're sued. You should be able to find out, hey, there's no low-hanging fruit, or hey, these are the limitations in my patent, whether they're in the independent claims, the dependent claims, that I'm simply not seeing in the prior art that the searcher found, and also in the prior art that's cited on the face of the patent. You simply can't rely on the fact that it was presented to the office as being a reason for not doing a search, or that the claims will ultimately be found valid over that cited art. Because as we've all seen, if the examiner didn't actually talk about a specific reference or a specific combination, it's fair game for the PTAB to institute a petition on that. So this is like, you need to go through the cited art, do your independent search, come to me and say, these are the limitations I think they're gonna have trouble finding in the art, whether it's through a combination or a single reference, and I'll probably do my own search after that to kind of confirm that. And that way I can focus on something very narrow. I don't have to do a broad-based search and kind of start from scratch. So if you've done that when you've come to me, the chances of you getting a funding deal probably doubled or tripled.
Yeah, and I will say, prior art searches can be sometimes not possible for certain claimants, and one of the reasons they're searching for funding is because they don't necessarily have the capital to invest in even a prior art search. We can solve for that as well. So if we get a good initial sense of validity and other merits and damages issues based on everything but the prior art search, that we have enough confidence in that, we can actually fund that either as a seed funding arrangement, then we have rights to fund if and when the prior art search yields good results, or alternatively we can just include it as a reimbursed cost so that the claimant will fund the prior art search, or the lawyers will, but then once we get into a closed agreement, which could be a month from that point in time, we would then reimburse that at closing directly back to whoever funded it.
Can I ask a question there? I just wondered, because if somebody comes to you with something like that, you guys are both getting pitched constantly. So what is like a signal or a positive mark in the patent owner's behalf that might get you interested in funding the search? Because I know not all patents are created equal, not all patent owners are created equal. Some of them have tinfoil hats and nobody wants to deal with them, or that's the perception at least. So how do you get interested to be involved without them having already done due diligence on their own?
So sometimes there are indicators of success that are readily available without doing much work. So usually that's in the form of some type of history on the patents. There's so many patents that are issued every year, and surely many of them are infringed and many of them are valid. But the question is, do they support enough real-world tangible use, enough consumer commercial value to actually justify funding, especially in the US where budgets are pretty high? And so for a single case to run, $50 to $100 million in damages is not an unusual sort of baseline requirement. So we have to see that tangible benefit. Now, how do we get there, knowing that patent damages in the US are incredibly complex and expert-driven and almost binary, where two experts can stand up at trial and one of them will say this is worth $500 million and someone else will say it's worth $5 million. So to sort of triage that, the best thing is some kind of history where there's licensing on that patent to support some kind of rate that we can then apply so that it's not so speculative. Alternatively, good comparable license analysis, where if your patent itself does not have a license, you can go to KT Mine. It's a little bit less useful, but it's still helpful. History, even commercialization. So even unsuccessful commercialization can be an indicator of later success if there's a very good story and they developed a product with lots of interest, where we're seeing a lot of those indicators of secondary considerations, which also translate into market value. That can help us sort of do an initial weed out process. Having said that, even without that kind of indicator, we'll still look at many cases because it may very well be that we're finding a gem, but it's kind of hidden and it's not necessarily clear with prior history.
Yeah,
Anoop, I'll ask you the same question. What are those indicia that you look for?
Yeah, I think one of the things I want to look at is if you don't have a prior art search, if you haven't really done that, what's your reason for doing that? As Sarah mentioned, maybe your patent's already survived IPR in an unrelated case and has gone through some litigation, and I can kind of see hey, this is the invalidity contentions that were served in that case. Great, that's basically the same. Maybe it's probably even better because a defense counsel has actually spent the time putting together some combinations and had thought, hey, this is our best shot at this, and they failed. The other thing is that something that would prompt me to be like, okay, you haven't done this, you're coming to me with kind of a raw claim. You have good evidence of use, you have some trial strategy in place, but you haven't done the validity search, you're still kind of working out some of the strategy. Is when I look at the product that you're alleging infringes your patent, how important is that product or that feature to the defendant, right? If it's if it's one of a million different things that go into a cell phone and it's not a particular note, yeah, there are certainly cases where people have gotten big damages on those types of patents, but it's less likely. If it's a product or feature that, hey, this defendant has based an entire Christmas advertising campaign around, well, that's certainly going to pique my interest in a way that's completely different than sort of your run-of-the-mill, hey, this is just, just to use an example, something that reads on a very minute portion of a 3GPP standard, which, the value is a little bit more uncertain. And, comparable licensing, I think for us, they can be helpful. The problem is a lot of those times there's still not going to be a good indication of what the value is when you get to trial. As Sarah said, you're going to have an expert on your side. It doesn't matter what your license is. They're going to find a way to tear it down. So, damages, from my perspective, is almost more of an art than a science, especially at the early stages. And you have to just trust your instinct that you've seen enough cases, you have a good feel for what probably will have a good damages case survive at the end of the day. And, sometimes, you can have people come in with experts, but it's so speculative. I don't know how helpful it is for me personally. And it's, I'd rather kind of judge based on what I've seen, what my experience has told me, what kind of damages are coming out in various courts, kind of concurrently to what I'm funding.
Okay. I have one last question before I turn back. So how important is it when, let's use Brad as an example. So Brad has lined up some attorneys to maybe on the litigation side and on the IPR side. And someone like Jim, who, I don't know how you do this, but you have a 95+% win rate for patent owners. And they put this kind of team together. How before they've come to you, and maybe Brad has had Jim do a little bit of work. Maybe he's had some of the litigators do a little bit of work. How important is that whole package of the team? Like the way it would be for funding a startup. Funding startups is all about the team in place. How important is that?
It's very important. And a lot of this business, it's still a relationship business. And I'm probably going to be more likely to fund something with, a team that we've been very successful with in the past, or a team that I know has been very successful with other litigations, even if they weren't funded by me. So I think that is one way to really differentiate yourself. If you can get sort of the combination of, hey, I've got a district court litigator who has, a history of large jury verdicts, and I have a, corresponding IPR counsel who almost, does a lot of patent owner work, wins a lot of patent owner IPRs for patent owners, and they know how to work together. That's a huge benefit to any claim holder.
Yeah,
Do you agree,
if
Sarah?
a case is a car, it only drives well if it's being driven by someone who knows how to drive. And so if the case is the car and the claimant and its counsel are the drivers of the car, and maybe they switch roles sometimes, maybe there's someone in the back seat sometimes, to us, the whole package matters. And so there are claims that I'm thinking of right now that could have resolved for a great value, but the people who are driving the case weren't looking at it realistically. They weren't looking at settlement offers that were actually quite good rationally. They wanted to keep rolling the dice, and ultimately lost the case on final adjudication because they didn't take that offer that was in hand. And so the case was strong, but people driving it weren't necessarily thinking straight. And so it definitely matters. I mean, you can't have one without the other. It's something we would consider as equal considerations.
Great. Jim, go ahead.
I like that analogy. That's good.
I was going to ask just quickly, I think you've done a good job of identifying best practices, but is there something you could share in terms of, you see a lot of packages come through. Are there recurring missteps or counterproductive things that folks are doing that, you'd like to see a little bit less of?
I think I'd like to see less hesitancy about bringing in separate IPR counsel. It's one thing if you're at a firm and you have an internal group that is sort of separate from your district court litigators, and that's all they do, because it's such a specialized court. The judges, they don't respond to the arguments the same way as a district court judge or a jury would. You really need someone that sort of lives and breathes PTAB, I think, to be successful. And so, we've kind of, we're going to the point where unless your firm has a dedicated team that does this and they have a large, long track record, we're going to want to bring in, somebody like Jim, some patent owner side IPR counsel that, that's what they do. And I think that's probably the biggest misstep I'm seeing these days. But it used to be in the past, I would say, when I think Sarah and I both started around 5 years ago in the funding space, you would get all types of quality of packages coming to you. That problem has sort of gone away. I mean, counsel and claimants have become much more sophisticated in how they present to funders. And there's not a lot of sort of low-hanging fruit that I can just say that, oh, this is a garbage claim. I'm not going to spend much time looking at it. Things are coming to us pretty polished these days. So those types of missteps, I think, are rare.
Yeah, I think, by the way, my 5th year anniversary in funding was yesterday. So that's exactly right. I think one mistake that does connect very well to this general conference topic is putting forth a case that looks great, it's very glossy, but it's entirely premised on the broadest claims. So claim 1 of this patent, claim 1 of this patent, claim 1 of this patent. Okay, looks great, but that's great, but what if, right? So that's fine to have that as part of the application and the analysis, but we want to see what happens if you don't get that claim and you're stuck with the more narrow claims because of the IPRs or other validity challenges. Do you still have infringement? And be honest about it. Be really dispassionate, just like we are when we look at this, and poke holes in your own case, whether you're the claimant or counsel, IPR counsel or litigation counsel. Poke holes in it. So what are ways that it's going to be harder to show the damages? Because is this a more incremental benefit? Yes, it's probably valid, and even if you can show infringement and add that extra element or two, is it really going to support the same royalties that we've been relying on for claim 1? And if the answer is probably, and we don't feel like they've necessarily thought about it, we're going to want to dig in further. We don't give up. We'll just dig in further. And so I think that's one, I guess, something that people sometimes overlook that we really want to see. That can cause issues for funders that don't ask those questions and don't necessarily get to the what if world when you get into diligence. So the kind of underwriting I'm talking about, I'm sure Anoop is talking about, is all happening before a term sheet is issued and negotiated and signed. So we're doing all of this under no exclusivity, really at our own cost and use of our resources and opportunity cost. Once we get into diligence, with a signed term sheet, that's where funders are asking for exclusivity. 30 to 45 days is normal for us. And we know that's asking a lot of the counterparties. They're not talking to their funders. They're really giving it all to us and hoping that it will close. Now, we want to be as fast and certain as we can, but I think in that situation, the diligence period can become elongated when the broadest claim, the premise of the entire application falls apart. And then we have to go back and say, okay, we're not comfortable with this claim. What other claims are infringed? And if they haven't done the work, they haven't thought about it, and if we didn't ask the question, that can sort of delay the entire process. And now we're in exclusivity. So I would say if I were advising claimants like Brad and others who are looking for funding, I would say it's better for you to do the work up front. It's going to be a little bit more time investment, but you can do all of that and still shop around, not be locked in, not be relying on a funder to give the thumbs up. That way, when we hit roadblocks in diligence, there are immediate answers and we can quickly pivot. And yes, it might change our investment thesis, but we already know there are backup claims and they also support the same value. So it doesn't disrupt the process, it doesn't take longer, it doesn't change the terms.
That's a great perspective, because I see a lot of petitions in the PTAB that focus on the independent claims and don't do that good of a job on the dependent claims. And that can be like a secret lane for patent owners.
Yeah. Jim, I'm actually kind of curious about your experience there, because sometimes what I've seen is that on the infringement side, I think it's absolutely right. Don't be afraid to chart out your dependent claims. Find the limitations that you think are just not present in the prior art. Tell me what the infringement looks like on that. Tell me what the damages look like on that. When you get to the petition stage in the PTAB, though, I've often seen that you almost get steamrolled a lot. If the independent claim is found invalid, the dependent claims kind of fall like dominoes. And so for validity, I think it does make sense to really focus on those independent claims, especially at the diligence stage, to be like, hey, we think the independent claims are going to survive. So it's almost it's the inverse of the infringement read, right? You want to plan for the worst case scenario, which in the validity case is that the independent claim and all its dependents are gone. So if you can have the independent survive, and I feel confident that, hey, the independent has a good chance of surviving, I'm going to feel much more confident about your case moving forward.
Yeah, I think the steamrolling, stand or fall idea, the blame can be placed at the feet of patent owner counsel at the PTAB, because they too often focus too much on the independent claims and not enough on the dependent claims that may have been given short shrift in the petition. If the read is good, and of course we cooperate with the litigators to see what the read is. If the read is good, we might give equal attention to dependent claims. So how should somebody choose a funder? You guys all have a lot of money to give out, and the best applicants probably you might all of you want to fund. So how should somebody choose a funder?
I guess that falls more to me. It's someone you like working with. So it's going to be a very long process. This is likely going to be years. And the old saying, everyone has a plan till you're punched in the face. Things are going to change on the ground, and you have to at times go back to the funder and talk about the new situations that have come up. And if you don't like working with them, and if you don't necessarily agree with their legal advice, they don't give you counsel advice, but they do give you opinions on the strengths of your cases. Then that makes it very hard. So you have to have someone whose opinions you respect and that you just think, hey, do I want to work with this person for the next 4 to 5 years?
Sarah and Anoop, how do you advise people to choose between competing funders?
I think that probably a big one is the same thing that we consider when we're selecting claimants and counsel for funding. So all things being equal, 5 cases equal strength, we're going to start looking at alignment. And so are our goals, which are a settlement on the merits without taking too much risk in a certain time period, is that aligned? Are those goals aligned with the people we're funding? And I think on the flip side, for claimants that are looking for funding and their counsel, they should also consider alignment. So there are lots of funders. Some of them are very old, some of them are new. They all have sort of different objectives, and it's worth doing a little bit of research into where they are in their life cycle. I think some funders who are just getting started, we hear about, they have mandates to sort of almost like in a loss leader fashion, just really put out a lot of money, put out a lot of commitments, and show investors that they should be getting more capital. To me, that could create some misalignment, especially if they don't necessarily recognize the risks that we and Anoop do with experience having done patent litigation ourselves and having teams of people who have done patent litigation, understanding how risky this all is, that it's not billion-dollar, headline winning. Not every case is like that. We hear about funders who perhaps are a little bit too rosy-eyed when it comes to patent cases because maybe their friend at a hedge fund made a lot of money on some case and they're trying to get started. And that can create a lot of misalignment because are they just using this to sort of test out a new market? Are they really committed to stay the course? And as Brad said, it can take many years. Are they really assessing the economics in a way and being very careful about the amount that they're funding, maybe even setting up milestones to protect their capital and by extension the funded parties until certain risks are overcome? And we start seeing these cases that we suspect are being funded for 3 times the amount that it's probably worth. And what that means is that the funder is probably entitled to many multiples of that money, and that ends up being a significant share of whatever is actually collected, which can disrupt settlement and lead to very unfair results. So understanding alignment and sort of is the funder investing in this case because, like us, the claimant and the counsel, we believe that it's very strong, we have a rational strategy for resolving it in a way that doesn't require years and years of trials and appeals and remands. And is this funder on board for that? Do they understand that this is valuable, but it's also limited, and that are they being realistic about the value of the case and likelihood of settlement?
Yeah, I think when things are going well, it probably doesn't matter who your funder is, right? The money is money. If you're just kind of chugging along and winning everything, it probably doesn't matter. The question you have to ask yourself is, what happens when inevitably I lose something? Because it's always a high risk in patent litigation when you're a patent owner. So what happens when if I lose on 101 that I wasn't expecting? What happens if I lose on the PTAB? What happens if I get to trial and I lose? Is the funder going to kind of work with me creatively to figure out, hey, is there a solution to kind of still find a way to monetize this? Or find a funder that you trust to be like, hey, if the funder is telling me that maybe this is done, I know I'm passionate about my own case. You're a patent owner, you want to see victory at the end. Sometimes it's just not possible. And so it comes down to trust. How much do you trust your funder? How much do you trust their opinion? And then are they going to work with you when the chips are down? And like an example, we just had a case, a bit ago We settled with one, the plaintiff settled with one defendant. There was another defendant, went to trial. We thought it was going to be a damages issue, right? Maybe we win on infringement, we win on validity, damages don't come in that high. Completely bulldozed when non-infringement comes back, right? And for some funders, maybe that's just it. That's done. Others, we're trying to find ways to listen. Is there a foreign equivalent? Are there some foreign patents we can assert? Is there anything we can do to give some life to this to this litigation within reason? We're not going to pump in another $10 million into a case that's lost at trial necessarily, but there are things on the margins that you can do to try to generate some value, and different funders are going to have different perspectives on that. So I think that's something that you should ask your funders: what happens when I lose, and what happens in this scenario, what happens in that scenario?
Yeah, and there's subtle things too. So I think people might be prepared for questions like that, but we'll see. But there are subtle things you can look for, like, is the funder talking about things that aren't only in their interest? Are they putting things in the pricing and the structure that actually benefit claimants and their counsel? If so, I think it demonstrates that this funder is thinking about this as a partnership, and they recognize that they're not going to be in the driver's seat. So they need the people who are originating the asset or have purchased the asset, putting it up for monetization, and they need the counsel who are also likely taking a lot of risk as well. We need them to be motivated. So the other day I was doing a term sheet, and I said, law firm, I don't think you're getting enough. I'm going to make, instead of 10%, I think you should get to 15%. And that's the only change I suggested. And they're like, why?
What kind of trap was that?
It's because we ran scenarios, and we realized that in some very good settlements where we would make money, it'd be substantial, and it would be enough for the claimant. Certainly, the law firm wasn't getting enough to be motivated, and we're thinking about how much they invest in their fees and what multiple of that would they get from what we all considered a good result, and realized that we didn't need this much. And it's more important for them to take that share away from us so that they would be motivated. Otherwise, we might be rooting for some settlement that they actually don't try to get, or they don't work hard to get because they're not making enough at the end of the day.
That's a really interesting story about the alignment.
Yeah, you never want to be in a position as a funder where a settlement does come in and the claimant can't take it, because they have final say on settlement, right? We can't veto them. We can't really do it. They have the final say on strategy and settlement. And they can't take it because the funder is just getting too much, but it's a real settlement. And you want to structure that at the beginning and make sure that your structure of your, like Sarah mentioned, alignment, like you want to make sure that you are getting appropriate payout for the risk that you're taking with your capital, but the claimant is almost always going to be in a position to take a real settlement offer when it comes in.
Well, and that actually relates very well to what I said at the beginning, which is milestones. So one way that we solve for PTAB in our structuring is to figure out how much money are we willing to risk and how much money would be supported even if there are substantial losses at the PTAB. So this is an exercise of, okay, your case is worth $500 million, but if so-and-so things happen, which are all things we have to assign some realistic probability to, at the PTAB, it could collapse to $100 million. Still sounds like a lot, but the amount of funding that would be supported by a $500 million investment is very different than the amount of funding that would be supported by a $100 million case. And so we figure out exactly how much would be supported in that worst case scenario of a smaller case, and we only unlock that until the PTAB is overcome. And we can define in different ways. If this is in a jurisdiction where the case is likely to be stayed, we could just say until all decisions are rendered, and no one has a problem with that because nothing's going on outside of the PTAB anyway. If it's in Texas where it's unlikely to be stayed, we'll come with some kind of middle ground where it's a flexible standard. But the point is, we don't want to put so much money, we don't want to put enough money in that would only be supported by the $500 million case, and then it's all unlocked. You don't survive at the PTAB, the case gets collapsed, and now we've put in so much funding that has to earn a return on our investment, and we eat up too much of the share, and then what used to be considered a very good settlement for the smaller case is not acceptable to the claimant because they would get almost nothing. They roll the dice, we go to trial, and then who knows what happens after that.
By the way, the panel is open to audience questions if anyone wants to jump in. Yes, sir.
How much of these discussions with your funders and counsel are discoverable? And how does that play into strategy?
Yeah, so I think, listen, I'm not going to claim that I am 100% up to speed on the case law, to the minute, but to date, for the most part, courts are still protecting sort of funder discovery under the relevancy standard. Even a judge like Connolly, who is much more aggressive about that. If you're just in a standard third-party litigation funding arrangement and you disclose it and you don't have control over the litigation, which we certainly typically do not, almost in every case. There's not much that you're gonna get out of it, and there are things that we will do to control for that. We certainly don't want, we don't want to be on communications that need to remain privileged out of an abundance of caution. Once a case is started, we will try to do things more over Zoom calls and phone calls so that there's less sort of email traffic going back and forth. But, especially with sort of the pre-filing packages that funders are getting, the way I look at it is that even if it was to be discovered, like any warts that I find, defense counsel is going to find. I'm not going to have found something that sophisticated defense counsel was going to have missed after litigating a case for a year. And what defense counsel is ultimately going to get is a claim chart that looks very similar to what they were provided for in their initial infringement contentions, some ridiculously large damages assessment, maybe a validity search which will be mirrored by whatever defense counsel was found that shows that, hey, these patents weren't invalid based on this search. And if they want to depose me, I'll basically tell them that, hey, I love this case enough to put my my company's money into it. So it's almost like it's not a huge concern for us because us, and I know Omni as well, Omni Bridgeway as well, we do everything above board. Now, if you have a funder that's not doing things above board, I think it's probably a much bigger concern. And I think the trend is that you're going to see more of that come to light.
Yeah, we've gotten subpoenas. Our funded parties have gotten discovery requests. We've never had to turn over anything like claim charts or really anything at all. I think we've had our LFA reviewed in camera with no issues. So there are sort of intermediate ways to handle these kinds of requests, which continue to come up in almost every case in the U.S. where discovery is available. But I do think there are some very helpful lines of defense. So first line of defense is relevance. It's not relevant, but I will say that patent cases sometimes are the exception. If you look at across all commercial cases outside of patents in the U.S., courts are pretty good about finding that's not relevant. With patents, we've seen courts, including Andrews in Delaware, so really key jurisdictions. There's some case law that suggests that, okay, it could be relevant to standing, because what if there's a third party and we need to know what are their rights? Do they have veto rights over settlement? Do they have control? Of course we don't, but they don't know that. And so some judges have found that this is enough for me to look at this in some way. Things like royalties and damages, they're just some patenty things that people have found resonate with certain judges. So we don't consider that the strongest defense. What we do consider very strong is work product. So the courts have really uniformly held that when work product is exchanged with a funder under NDA, even verbal NDA, but certainly a written NDA, that is not waived by disclosure to the third party, because the underlying sort of principle purpose of the work product doctrine is maintained, because the idea is to keep it out of the hands of your adversaries. Privilege is also available, but it's much more case by case. So different jurisdictions have found different ways. We don't like to rely on privilege, as Anoop was suggesting. And the reason is that some courts have found that, yes, there's a common financial interest with the funder, but not a common legal interest. And so there is waiver when you give privileged information over to a funder.
Yeah.
Oh, please follow up, yes.
Is there a fear that the other side, they can reverse engineer your funding agreement, if they can see that?
Well, generally, no. They don't actually see the agreement itself. So that would be more the in-camera review. The worst you're going to subject it to is they want to check and make sure that the funder can't actually control the case, right? That they're not a party. And once that's established, any funding arrangement is going to have different pressure points, and that's not something the other side gets to see.
And let me ask you, Brett, I think you've been following all this a lot and what goes on in Judge Connolly's courtroom and all this. Would you agree, and maybe I'll ask all of you, it really isn't a litigation funding issue that Judge Connolly seems all that upset about. It seems like almost like fraud, right?
Yeah. It's, the old bad cases make bad law kind of thing. He's trying to get to the bottom of something that smells bad to him. And,
And it smells bad to like a lot of people, right?
Yes.
I mean, this was like somebody bought patents and then found somebody who literally owned a food truck, right? And assigned the patents to the person who owned the food truck.
And then
that person sues,
yes.
And it was like...
The lawyers couldn't say who they're representing when they're in court. Like, there was so much wrong
subterfuge
wrong with it. that
I mean, it would get rejected by Hollywood for a C movie, right? Kind of thing.
Yeah, there's a lot of conflation on these issues that are before Judge Connolly by the media and others, where are we talking about, really disreputable patent owners who have a bunch of shell entities and, it's hidden, but it's really self-funding, they're owning the patents and doing bad things, or are we talking about third-party funders? And there's two different orders, and they often get mixed up a little bit in the reporting of the IP Edge issues and things like that. But on the I actually spoke on a panel with Judge Connolly at the District of Delaware Bench and Bar Conference. I was the only one in the room who was willing to interrupt him while he was speaking, and everyone gasped. But it was really fun, and I think I got the impression that he genuinely wants to understand this. I don't think he has it out for funders. I don't think he has it out for claimants. I do think he has that former prosecutor, mentality where, like Brad was saying, he wants to get to the bottom of this. He wants to understand, and what he's finding is disturbing. But these are individual cases that aren't really, I don't think reflect on the broader industry. Importantly, though, the order that has to do with funding is limited to non-recourse funding. And as we talked about on the panel with him, I commented that if the concern here is to uncover sort of disreputable people who are controlling litigation in a hidden way, and it's all frivolous litigation, then why specifically target non-recourse funders who are the least likely to control, as opposed to like a recourse funder who actually has more control over the assets, least likely to control and least likely to fund frivolous claims, because that is our only collateral. Whether we make any money at all, it's completely dependent on the success of the case. And so why are we putting millions of dollars into something unless it's extremely valuable and highly likely to succeed? And so I think those issues are starting to become a little bit unpacked, but it is a sensationalist type thing. So I don't blame the media for pumping it up that way, and it's very understandable.
Yeah, we've had nothing come of third-party funding disclosures in front of Connolly. Like, we've done it in several cases. You file whatever form that he has you file at the beginning of the case, and that's it. Like, nothing has come of it afterwards. So I think Sarah's right. It's two different issues, and they've been conflated, because I think a lot of people didn't understand that they're two distinct orders. And third-party funding is one, and ownership is the other, and beneficial ownership. So he's really on the latter. Who owns the company, who's the decision maker, who has the financial, who's getting the majority of the financial success, should there be some, and it's a different issue than third-party funding.
So it seems like Delaware is the most aggressive at allowing discovery into funding, and if that's correct, should that be a factor in forum selection?
No. I don't think it's really an issue at all. And in fact, if the other side finds out that you're being funded, that's just a benefit, because they know that you're well financed,
Right.
and are less easy to push around. So to me, it's not an issue at all. At least in the current iteration. If Connolly does something unexpected, maybe that'll change. But right now, no.
So go ahead.
Yeah, I was just going to say, I think you want to be in the best forum for your case, no matter what that is. And if it's Delaware, you go to Delaware. If it's Texas, you go to Texas. If it's somewhere else for whatever reason, you go there. You don't want to. There's nothing about sort of I'm in Delaware, I need to avoid it because one judge is on a mission in another unrelated matter. You just want to go to the best place for your case, and to kind of turn it back to the PTAB issue, right? Sometimes that means that, hey, maybe I want to be in a jurisdiction where the district court litigation is going to move a little bit slowly, because I do think the biggest risk I have is PTAB risk. And I don't want to be in a position where I'm barreling towards trial and all of a sudden these patents are invalidated on the eve of trial or after trial, because it's just not a good position to be in. You've kind of lost all your leverage. So if you can get through the PTAB first and the district court case is stayed, you have a couple claims survive, then all of a sudden you have so much more leverage moving forward to get that settlement. In other times, though, maybe you're not as concerned about PTAB risk. Maybe you can get into a rocket docket and you'd rather just kind of get to trial as quickly as possible, and you're gonna go forward with that. So it's important to just pick the best venue for your case based on sort of the alignment of strategy between funder, claimant, and counsel.
I like how you said the worst case would be you want to lose as cheaply as possible.
Yeah,
if you're going to lose.
That's certainly one way to put it.
I'm
good.
stealing that.
So do funders assume that there will be IPRs filed and build that into the funding structure from the beginning, or wait until it actually happens and then figure it out?
Right from the beginning in all my cases. And in fact, the biggest takeaway I've had over the past few years is increase that budget, or at least that budget allowance right from the get-go. It's more than likely you're going to get it, and you might get it twice, or there might be appeals or something else. So it's got to be there, and it's got to be pretty aggressive.
Or as a funder, if you have a budget and you feel comfortable with it for the IPRs, I might hold you to that. Like, you're not getting more money, because I don't want to have to put more money into the case because an IPR was instituted and you weren't expecting that. That needs to be built in from day one, when I have a lot more control over how much capital I'm going to commit to your case. But the minute, say, an IPR is instituted, well, that's a negative decision. It's the stats kind of bear that out. It's an uphill fight once an IPR is instituted. Getting more money out of a funder at that point, it's going to be tough. And if we're willing to do it, the terms, they might not be great for the claimant.
So heads up, everyone, I'm about to say something positive about IPRs. So yes, okay. Yes, we do take
Warning.
it into account, and sometimes it can actually make the case more valuable. And so the way that would work is, if we're likely to be filing, or we've already filed in a jurisdiction where we think there's probably some patents that will be instituted, but we're okay with that. But we think the case will be stayed. And so when we build in the likelihood of a stay, and this is a jurisdiction that might even stay all the way through appeal, that adds on 1 or 2 years or more of damages. And so when we're thinking about the trial damages number, that's often what we look at for how we value the case. Yes, there could be future damages, there could be lump sum awards that account for future infringement, but what we're thinking about is damages that have accrued as of the date of trial, because we find that in settlement, that number anchors the negotiation. People are really focused on whatever the highest damages number that the expert has been able to put forth, especially if it's overcome Daubert. And so when you have a case that has 1 or 2 years or more of damages tacked on, that can make the difference between a case that's borderline and one that seems like it's really going to support this funding. So because of the IPR, because of the possibility of stay, it's not expensive to incur that, but we don't have to put much more funding in, but it does generate more value, and that can actually improve the chances of getting something funded at a good price.
How would you three rank the PTAB in terms of the risk that it presents among all the other risk factors in funding or investing in a litigation campaign for patents?
It's probably number one. So by the time we're taking on a portfolio, we've already managed some of the risks. We take ownership, right? We're not letting people with realistic expectations still own the patents, things like that. So we've taken a lot of that out. Mm-hmm. The things that are out of our control now, the number one risk, most likely the PTAB.
I would say in cases where 101 is a risk, that probably trumps IPRs. And the reason I say this is because, one way we can tackle the IPR risk is diversification. We talked about multiple patents, multiple families, claims that don't rise and fall together, that kind of thing. It's a bit harder to do with 101, to find that diversification that gives us enough confidence that if one goes down, the rest won't follow. So it becomes a very binary risk that's a little bit different than the IPR risk. Also, now that IPR sort of decisions are not, the IPR risk is no longer being resolved at early stages for the most part. Instead, you could go through the entire case, all the IPRs, trial, everything, and get on appeal, and depending on the judges you draw, it could be a coin flip or worse, losing the whole case. And so in terms of losing cheaply, it's probably one of the harder risks where you can plan ahead for that. There's no way to milestone for this because there's always a chance that everything has been unlocked and yet you lose the whole case on 101 on appeal. Whereas IPR, it's easier to milestone it. You have stays that can actually be helpful to kind of resolve the IPR issue before we spend more money. You don't really find that naturally with an IPR risk.
I think I would say IPRs are more than 101 for me. I think that my answer changed maybe from when we talked an hour ago. But with 101, at the very least, at the district court level, you know which judge you're going to be in front of. You, as a, I guess, sophisticated patent litigation funder, know the case law around 101. There's, granted it's a mess. We all know that, but it's there, and there's some predictability. And I feel like, at least for me, I can, with 80% confidence, predict which way a 101 decision is going to come down. Because all the facts, at least, are there for me. I know the case law, I know the patent, I know the judge. With IPR, I think there's a little bit more unknown risk because you can't figure out all the art that's out there in your pre-filing diligence. It's just not practical. You can't figure out what combinations a defendant might think to assert based on what their own attorneys and their experts came up with and what their knowledge base is. So
And you don't get any say in the judge.
right, yeah, you don't know what
Either,
panel
so
you're going to get. You
can
don't
get
know
a
who the
very bad
presiding judge
panel.
will be. So there's just a lot of more unknown to the IPR, and I think the way we usually, like internally at least, look at the risk models, like even for the best case scenario, I'm usually telling my managing principals that we just have to treat IPR as like a 50-50 risk in the way we model the case. Now, obviously, there are things you can do along the way to mitigate that, as we've discussed. Good IPR counsel, structure your deals in certain ways to at least limit how much expenditure you have when you hit those goalposts, but it's still a large unknown especially with a pre-filing case.
Is the PTAB risk so high that it makes you you factor into that which countries you want to enforce patents in?
For me, absolutely. I'm pretty bullish on asserting in foreign countries, particularly with the UPC. I think I've been more bullish than a lot of people on it. There's a lot of uncertainty with it, but if you can file a case in these foreign countries in decent proximity to filing your U.S. litigation, all of a sudden the timelines are constrained for the defendant. Instead of having a year to file an IPR as they do in the U.S., in the UPC, you have 3 months to put your validity counterclaim in. If you're past the opposition period in the EPO, there's nothing they can do with the European Patent Office. Sure, they could choose to go to the national courts, but there's all types of timing problems with validity challenges in national courts. And so you almost, in a way, if you had the foresight to have enough coverage in the financial ability to have enough coverage in enough European countries in the UPC, you can really mitigate the PTAB risk by essentially taking the PTAB out of the equation because you're in a marketplace that's, it's almost the size of the US. I think there's about 300 million people in the UPC member countries. There's, 380 people in the United States. So it is a smaller market. They don't give damages quite as high as the US, but it's still a substantial market now. And it can really, I think it can really drive towards global settlements with pretty good speed and really getting rid of the PTAB risk that way.
I heard they still have this thing called injunctions over there. So we just have a few minutes left for each of you for closing thoughts or key takeaways. Sarah, let's start.
Can I interrupt before
yes,
we
please,
go
of
there? Since we started a little bit late, we can go an extra just 5 minutes. But
Okay.
there was one question I want to ask all three of you, and yours will be slightly different since you're a client. What types of technologies or patents are you looking at funding more often than not, or you're interested in something? Are you more interested in semiconductors or electronics and life sciences, or what's your interest, your wheelhouse? And for you, Brad, the same kind of question, because I know you mentioned that people are always pitching portfolios to you to buy or be interested in acquiring some interest in. What are you looking to acquire?
Sure. So it kind of comes at it from a different angle. We're a little bit agnostic as to the technology. It just has to have the damages. So it's a very expensive game to play. So if you have to go to litigation, if you have to be ready for the PTAB, and the PTAB is it's early and it's expensive, and then you get litigation financing from it, and everyone, the lawyers and the financiers, and everyone has to make money. So unfortunately, if you just have sort of the one patent, you can't really enforce it. You need a little bit more of a group, or if you do have that one patent, it has to be such a rock star patent that it just hits on everything, and which is very rarely the case. So you just have to have the damages. You have to be looking at the damages models are $50, $100 million if it actually gets all the way through to trial, that those are the numbers that you're looking at. And so we look at it from that way, and then pretty much any kind of technology. Now, are there some things we really like to see? Well, we don't want to see one-on-one things that have that much one-on-one risk. We don't want to see too much iterative improvements. Like a cell phone has, what was some of the estimates? 3,000, 6,000 odd patents go into every cell phone that you see. So it's a little bit hard to get the apportionment there. So ideally, you want to see that nice step up. You want to see a nice apportionment. You want to reduce the one-on-one risk, and if it fits into all those things, it would be great. It tends to be a lot more in the high-tech space, but that's sort of the arc of how patents get developed and how technology gets implemented. You have startups that try to push an idea, they get patents on it, they get incorporated by a large company, other people come and copy. So you're kind of looking at the fast-changing technologies where the patents are still, they're old enough to have been incorporated and they're still young enough to have some life.
Yeah.
So it's more the tail wagging the dog in that respect.
Great, thanks. Sarah, anything to add to Brad's answer, or you
Yeah,
look
so
at it different?
from my perspective, medical devices are actually pretty close to the top and kind of get to the top of the pile pretty quickly because medical device patents and cases that involve them, you can avoid some of the risks that are part of every potential opportunity. So things like black box infringement, there's often ample publicly available information about the accused products and how they're used that can serve as evidence of use. It's a little bit harder to get to infringement and evidence of use when it's like a software where you do have to have teardowns, for example. You don't run into as many of those issues. It's obviously very sympathetic technology. There's usually a good story behind it. It's easy to spot fundamentality. You have sometimes better evidence that's readily accessible of commercial success and secondary considerations that can help with the PTAB challenges. And it's less subject to apportionment. So also, I think good comparables for elevated royalty rates. So we might be willing to assume 5% royalty rate across entire revenue, whereas in other technologies, we usually assume less than 1%. And on the flip side, obviously, it doesn't need to be said again, the 101 risks, the apportionment issues, is this really fundamental or is this just an incremental benefit? Those issues that come up a little bit more on the high-tech side, I think are mitigated with medical devices. So what's the downside? So I would say, claimant risk is usually higher, at least in the cases I've seen that are attached to medical device IP. Often it's, a surgeon, single inventor, sole inventors, perhaps a failed startup or even an existing smaller company where they might have more complex goals like acquisitions. And so I think in terms of alignment, it can be a little bit harder with claimants on that side of the spectrum.
Yeah, we're also technology agnostic, with the caveat being is that Curium's a little unique in that we have a lot of capital, but we're a small fund in people, right? So the only IP person internally is me. So I have to do everything. And so
Who's doing it today?
me after I go back to my hotel room. So a lot of it kind of just depends on how quickly I can wrap my head around technology. So anything in high tech, stuff I practiced in high tech, medical devices, typically you're going to go, to the top of the pile. I'll tell you that I'll look at a life science patent, but realistically, we're probably not the right funder for that because I don't have the background in it. I don't want to tell you the grade I got in organic chemistry in college, and that was 20 years ago. So that's sort of how I would look at it, is that the more quickly I can get around it, the more I sort of like it personally. And then the other part, and this is only like kind of tongue-in-cheek, is that if you can assert it against some of my old clients that I don't like that much, maybe that also goes to the top of the pile.
And who are they, Anoop?
I'll tell people that in private.
I know, I'm just kidding.
The reception.
Jim, take it away to wrap up.
So, time for closing thoughts, takeaways from each of you, 30 seconds or less. Sarah, go.
Okay, so I would say, contrary to some popular opinions, the PTAB doesn't have to be a binary risk. I think if you plan your strategy accordingly and ask the great what if questions and find different alternatives, plan B, plan C, plan, et cetera, that it can be a more diversified risk where you may not get everything you want, but you could be left with something that's still just as good and supports the funding and the investment.
Thank you, Sarah. And that was less than 30 seconds. Well done. Brad.
I would go back to how I started. It's just numbers. You try to go in with multiple asserted patents, multiple assertable claims, and a really good budget.
Thank you.
I beat Sarah too on time.
You did. Anoop.
I'll be very short. UPC.
Well, you are the champion. Well,
And what's your takeaway message, Jim? I mean, maybe I can ask you like this: when people come to you for IPR representation, for example, what do you tell them about funding? If let's assume that they have not contacted a funder yet, what advice do you give them?
they should contact a funder.
Yeah.
And I'll say this too, and see if you all can provide any insight. In the earlier years, funders would always ask me for, well, first a budget, and then second, come back with say, hey, how about a AFA, an alternative fee arrangement? And I would say, okay, here's a structure for that. And then always for years, the funders would choose the hourly arrangement, not telling me why, that's fine. I assumed that it was because the funders wanted to make investments and retain the reward for the risk. Lately, I've seen it switching a little bit, where funders are more interested in having us do the AFA, which is fine with us too. Am I imagining that switch, and what's driving it?
I'd say it's actually hard to fit it in, because you want to reward the IPR counsel if they're distinct from your main law firm for doing well, but you don't have anything to reward them with when
Not yet.
when you've had a successful PTAB. So it's probably just been hard to make it fit and come to an arrangement that works for the stakeholder as well as the IPR counsel. And so maybe you've seen some more creative approaches to that.
Yeah, I mean, I think much like we really like litigation counsel to be on some kind of risk to maximize alignment, since they're incentivized for the same successful and valuable results as we're looking for. It fits with IPR counsel as well. It's just different. So it wouldn't really make sense to have IPR counsel taking a ton of risk in exchange for some percentage of some result that they just don't have the same insight into. And I wouldn't expect Jim or other counsel to take on that kind of investment. But what we can do is a modified, and I do like it better than hourly, where under an hourly basis, a rational IPR counsel would actually want the patent to be instituted, because then they make more money. It continues, like the same bad incentives that drive other hourly lawyers in other areas exist. And it's not because these are bad people, it's because it's rational. So how do we solve for that? We can give them a certain budget that if they are successful, they get a kicker. So they actually get more, maybe not as much as went all the way through, but they get a success fee. We can cap it, get a small discount, and then a true up and another kicker if there's success. So there are ways to kind of play around with it where it's a modified, smaller risk, not contingent on the entire outcome of the case, because they don't have the same control or insight into that as the litigators do. But still something to reward them for success and just incentivize them to be efficient and try to avoid institution, try to get good results that will drive everyone's success.
Yeah, I would say for IPR counsel, we really want flat fees on legal costs, and then like Sarah mentioned, success bonuses basically. Like you institution denial, it's a certain percentage bonus. Final written decision win, it's another percentage bonus. The total amount of money might be more, but the percentage is going to be smaller, so that there is some incentive to get this kicked out at institution instead of dragging it through to final written decision. Not that I think any of the counsel we're using would want to do that, but just to make sure that all our T's are crossed, I's are dotted.
Thank you. I guess I'm the loser in terms of taking up too much time on my closing issue.
No. Thank you all. Thank you all very much. It was a great conversation. I appreciate it.